The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good morning. We have three cases that will be submitted. They are Larry Hedlund versus State of Iowa and others, State of Iowa versus Toby Richards, and Deanna Jo Ramirez Trujillo versus Quality Ag, Wright County, and others. That last case is submitted to the court now without argument, and we'll hear the arguments in the Hedlund case. Mr. Duff.
May it please the court. Good morning. My name's Tom Duff. I represent the appellant, Larry Hedlund, in this case. This matter is before the court on an interlocutory appeal following the trial court's granting of a motion to dismiss a single, well, there's multiple counts in the petition, but the count alleging public wrongful discharge in violation of public policy. The reason the trial court granted the motion on that count was because the court believed that Mr. Hedlund did not state a clearly defined, well-recognized public policy, and secondly, that Hedlund had an optional remedy available to him under Iowa Code Section 80.15, which the trial court felt diminished his compelling need for protection from wrongful discharge. The relevant facts in this case were that Agent Hedlund was a special agent in charge working for the Department of Criminal Investigations. He was on duty traveling on Highway 20 in his state-issued vehicle when he saw a black SUV with tinted windows doing what he described as a hard 90. He followed the SUV, phoned dispatch, and a Hamilton County deputy was dispatched, clocked the SUV going 84 in a 65-mile-an-hour zone. The Iowa State Patrol was also dispatched and on the scene and followed the SUV. The pursuit was called off after the trooper determined that the SUV was being driven by another state trooper and that the passengers in the SUV included the governor and the lieutenant governor. Within days of this event, Agent Hedlund sent an email to his boss, who's the director of the Department of Criminal Investigations, and to the commissioner of the Department of Public Safety. He relayed the events that occurred with regard to the pursuit of the SUV and stated that as the ranking officer, he should have stopped or insisted that the SUV be stopped, and then stated his intention to contact the county attorneys for the two counties that the SUV went through for further legal action. About 5 days after sending that email to his superiors, he was suspended from duty. A lengthy investigation ensued, internal investigation, and Agent Hedlund's employment was terminated on July 17, 2013. We believe that Agent Hedlund did state a clearly defined and well-recognized public policy claim. The source of the public policy that we asserted in the district court and assert here is statutory in nature, found within Chapter 80, which is titled Department of Public Safety. 80.9 says it shall be the duty of the department to prevent crime, to detect and apprehend criminals, and to enforce a criminal law. More specifically, and we think on point, given the facts in this case, that as a sworn police officer, Agent Hedlund had the duty to enforce all laws relating to traffic on the public highway, including those laws relating to the safe and legal operation of cars, and to ensure that the rules of the road are followed.
Counsel, is that source too generalized? I'm thinking of the Drake private security guard case where we said that was sort of a too general a duty to support a public policy claim. Is a state-employed law enforcement different in a way that should lead to a different outcome here?
Well, I think it is, and I think the Lloyd case, which the trial court and the state relied on, it's our position that that case is actually supportive of our position that Agent Hedlund stated a cause of action. There is one of the distinctions, important distinctions that the court made in the Lloyd case was that he was a private security guard. He had no statutory or other duty or obligation to enforce the criminal law at all, which is completely different than Agent Hedlund, who is a sworn police officer. He's sworn an oath under 80.15 to enforce the law, and that is a critical distinction here. With regard to the issue of whether the statute that we rely upon is too general, again, the distinction in Lloyd is that there he didn't point to a specific statute. He just said, well, it's generally a good idea to enforce the criminal laws and to uphold the criminal laws, which this court said, well, that's just a little too vague.
Mr. Duff, kind of getting to the second part of the district court's ruling. I mean, normally we think of the wrongful discharge public policy remedy as we're kind of filling in a gap. In other words, the legislature has made a clear statement that something is an important public policy, and we further that public policy. We kind of fill in the legislative intent by protecting people who are discharged for pursuing that or protecting or trying to advance that public policy. In this case, your client has, under 8015, a statutory remedy, and he had the ability to assert, and probably this would have been a good defense if your allegations are correct, if he was discharged in retaliation for reporting criminal conduct or a speeding violation or whatever. So why doesn't that kind of take this out of the realm of the common law tort?
Well, we think that the 8015 is, as the trial court pointed out, is an optional remedy, and that's the words that the trial court used, that was available.
All remedies are optional, right?
Correct. But there's nothing in 8015 that says that he must. It's not an administrative exhaustion requirement like you would find under the Iowa Civil Rights Act. It's an optional remedy, and one that has a limited remedy. His only remedy was reinstatement, and
that's exactly what the tort is supposed to protect. It's supposed to protect the security of your employment. So I understand you may have other damages in addition to that you might be asserting other than lost wages, but isn't reinstatement kind of what the public, a remedy that drives at what the public policy tort is supposed to protect?
Well, I'm not sure that it does, because what this sort of gets into this issue of whether 8015 creates some sort of contractual recovery that makes him a contract employee that might not otherwise be entitled to assert this claim, which is a different issue. But the under 8015, the fact that all he can get his job back, I think, does not promote the public policy.
But that's not quite accurate, I don't think. And please correct me if I'm wrong, but under 8015, as I read it, you don't get suspended. I mean, you continue to get pay until you have an ultimate adjudication. In fact, it seems to me, and I'm looking for guidance from you, to the extent he has a contract claim, 8015 kind of takes care of it. I mean, 8015 really kind of is contractual in nature. Now, then you might have a tort claim, I guess, and I did see that in your brief. You're talking about other damages that ordinarily aren't contract damages, emotional distress and so forth. And that may be true, but then you have to file a tort claim through the tort claim process, it seems to me. So the overarching question, I guess, is public policy may have a tort element and a contract element. Your contract remedy is through 8015, and the tort remedy would be through the Tort Claims Act, I think. That's my theory, so help me.
Well, and we
out.
did, the tort claim obviously is the public policy wrongful discharge claim, which we did file a tort Claim Act for and got it into the, through the process. But the contract, and I think the thing to keep in mind is that the contract claim, or what sometimes is called the contract claim, is not the exclusive remedy. And there are decisions from this court, Sanford, the Lockhart case, where the court talks about people that are union employees that have a right, basically a contract right under the collective bargaining agreement to grieve their termination, have a for-cause hearing, get their job back, get back pay, and so forth. And the court has held that does not take the employee, that even if you have those rights, you still have the right to file a tort claim alleging wrongful discharge in violation of public policy. They are not exclusive. And I have some problem with arguing that 8015 creates a contract right. If you look at the contract cases, I mean, this was not a arm's length contract negotiation between Hedlund and the state of Iowa. It was a statutory.
It's kind of like a unilateral contract. I mean, it's a little bit like an employee handbook that, I mean, it seems to me somewhat analogous to an employee handbook. He gets his job and it's subject to, the relationship between the employer and the employee is subject to 8015, much like a handbook that doesn't have one of those fancy disclaimers. No?
Yeah, yes, but I don't think that's any different than, like I say, with the employees that have the right to collectively bargain. And I think the difficulty with going down that path is that anytime you have an employee that has the right to, file a grievance, file a merit claim, merit-protected employees, union employees that are state employees, municipal, county, private, if those people are foreclosed from filing a tort claim alleging public policy because of...
Couldn't we draw the line here? I mean, I understand your point about contract employees. So we could say at-will employees can file the public policy tort, and contract employees can file the public policy tort, because even if they're subject to a collective bargaining agreement, that the agreement between those two private parties may not adequately further public policy. The employer may still do something in violation of public policy, or the employee may still be advancing public policy. But in this case, where the legislature has spoken and you have a legislative scheme that protects the individual's employment and assures him, in this case, against being discharged without good cause, why are we now creating a common law tort on top of that? Isn't that a kind of a different issue?
I'm not sure it is, and I have some dispute with whether it's a good cause standard. If you look at the 8015, it says during his period of probation he's at will, but then it doesn't say that later on. It doesn't say after he's through with his probation he's not at will and he can only be fired for good cause or just cause or something. So I have some question about whether that's really the standard, and the legislative history of the statute would indicate that prior the act, the Department of Public Safety was created in 1939 when they sort of joined all these other statutes together, and one of the prior statutes actually had the word, from this statute, 8015, used the word cause, and that was removed from the statute, and it's never been put back in, despite the fact it's been amended several times.
I have a question, factually. Did the department file charges with the Department of Inspection and Appeals and do the procedure under 8015, or did they terminate him without that?
They did not file charges. They did not do that, no.
I want to go back to the public policy arguments that we have here, and according to your brief, you're relying upon not only the whistleblower, but also the refusal to participate in illegal activities. And I'm having a little bit of struggle with, I understand the basis of it under the statute that you're to enforce all traffic laws, but here we had a case, as I understand it, where a judgment call was made that you're not going to stop a vehicle for speeding. Those are the kinds of judgment calls that I assume law enforcement officers make all the time. So I'm really struggling with the idea that this is a refusal by Mr. Hedlund to participate in some type of illegal activities.
Well, and that actually comes from paragraph 32 of the petition, where he stated that no one had the authority to order him not to do his job or to violate his oath. The thinking being that no one stopped this vehicle, no one ticketed it, nothing was done to prosecute the speeding of the vehicle, and that he was not going to be complicit in allowing that to continue. So
Is that an illegal activity?
well, the speeding is a legal activity and not, I mean, I would argue that an agreement among state officials not to prosecute another state official for speeding is criminal activity.
So what if they would have stopped him and they would have given him a warning ticket? Like, I think people often get a warning ticket. You know, they tell you to slow down and they give you a warning ticket. Would that have been illegal also?
Well, I think if the vehicle had been stopped and the driver had been given a ticket or a warning or something like that, I'm not sure we'd be here. I guess I have 30 seconds left. Yes, I think what I want to say about that is that in the original argument that we made, when we filed our motion to reconsider and enlarge, we did argue facts that were not in the original argument. One fact being that he was a sworn police officer, that he'd taken an oath, and that obviously is very important to the Lloyd analysis. And we also attached, with regard to this 8015 issue, we also attached and made arguments about the fact that we had filed a declaratory judgment action with the Department of Inspections and Appeals to get a ruling on whether there was an exhaustion requirement or a requirement that he pursue 8015. So those were new facts that were asserted in the motion to reconsider.
But where does that leave us procedurally? I'm a little confused because it's a motion to dismiss. And a motion to dismiss, you take all well-pleaded facts as true. And then I think, as you've recounted, you've presented, I guess, additional facts that were not within the four corners of the motion to dismiss, or I think you see maybe my procedural problem. I kind of thinking, well, ordinarily on a motion to dismiss, we've got a question of law, I gather, and I'm kind of confused. So help me.
Well, I think it is a question of law, but the additional facts, I guess my argument would be that we asserted additional facts that were not were not pled in the petition, but certainly related to the court's interpretation.
You kind of turn it into a motion for summary judgment at that point. I wonder. I mean, I'm not sure. But it just strikes me as a little bit odd.
Well, they were facts we thought that were relevant to the court's legal analysis, so.
Thank you, Mr. Duff. Mr. Peterzalek?
Thank you, Your Honor. May it please the court, counsel. Mr. Hedlund doesn't even get his foot in the door on a wrongful discharge case because, as we've argued in our brief, Iowa Code Section 8015 provides his exclusive remedy for challenging his termination.
I have a factual question about that. 8015 says that the department has to file charges.
Yes.
With the inspection appeal. Do they do that factually?
Absolutely, yes.
Is that on the record here somewhere? I couldn't find it, and maybe.
Yeah, I don't, if you go through the process, I mean, obviously, they filed, if you go through the supplemental authority presented even by the plaintiff, they went through, I think if you go through his petition for declaratory order and the order that was issued by the ALJ, it touches on that. He went through the process. Obviously, the process got started, or we wouldn't, the process got started by charges. Mr. Hedlund appealed. There's information, I believe, in the record that indicates he abandoned that appeal and then filed these charges. I think there's actually information in the record that he believed that he would be better off filing the tort as
When
opposed
did
to
you,
this.
when did you terminate him, or not you, I'm sorry, when did the state, when did the state terminate him? Was it after he abandoned his appeal, or was it during the appeal process? I mean,
He was never terminated, as I think it was Justice Mansfield pointed out, or maybe it was Justice Waterman, that during the 8015 process, you continue to get paid. He was not ever terminated. In fact, I'm not sure it's mentioned in our
they
brief.
allege in their petition he was terminated.
He was not terminated. He was on paid administrative leave until he retired. So he was not. He was not at any point in time. The termination was never finalized in this case.
We have to take the well-pleaded facts as being true in the petition, which say he was terminated without an 8015 hearing. I mean, that's the problem when you do something on a motion to dismiss, is that, you know, the record never gets developed and we have all these loose ends. I mean, so how do we go outside the petition and say that 8015 applies when we don't know whether or not 8015 was done? I mean, that's my problem.
You know, first of all, 8015 is exclusive, so that's the remedy in this case, and I think that's.
I understand it's exclusive, but it's only exclusive if you start the 8015 proceeding,
and
there's nothing in the record to show that you started the 8015 proceeding.
I think there may be some information, especially if you look at the information the plaintiff himself provided with respect to the declaratory order that would indicate that. But that said, if the agency didn't follow 8015, that the remedy is still to go through that process and say, hey, Employment Appeal Board, I didn't get my hearing, I didn't get my charges, I can take that up on judicial review, I was wrongfully terminated.
But he should be paid now, and like I said, the petition says he was terminated by the department. I mean, that's my problem. I mean, maybe it's my problem with motion to dismiss this rather than.
Well, and I think it is, but I don't know that your concern affects the exclusivity of Chapter 8015. That exclusivity applies, and it's consistent with exactly how municipal and county law enforcement officers are treated under Chapter 400, the Civil Service Statute. It's consistent with the exclusivity decisions that this court has rendered for decades.
What about the tort claim aspect of it? It may be exclusive with respect to contractual type matters, but as you know from the briefing, the suggestion is, well, Chapter 8015 has limited remedies. It doesn't include tort remedies. It's not designed to be exclusive as to tort. What's your view on that?
Well, yeah, I think that you have, if you go through the tier of employees, you have statutorily protected employees like Mr. Hedlund. You would have maybe collective bargaining unit employees. Then you would have employees at will or independent contractors. So, the fact that the legislature has chosen, as they have in other matters, the merit system, Chapter 400, to pass these laws and say, this is what your remedy is, this is what we should do, that's how we're going to set this up.
I guess but I'm not 100% sure, frankly, help me, the scope of the exclusivity. I mean, I think you've got a point. I'm with you. You've got me down the tunnel. I'm walking with you, but you got to get me to the end. And I think in terms of economic matters and traditional contract remedies and so forth, you've currently got me.
Okay.
So I'm that far, but
I'll try not to ruin that.
But so don't lose that. But I am not sure that 8015 should be regarded as an exclusive remedy for potential tort claims.
Oh, I think I see where you're going, and I think if you look at I think it's Von Baal, V-A-N-B-A-A-L-E case, which is a Chapter 400 case, that really kind of touches on that, where the challenge to the termination itself has to go through that process. But if you were to present a case, as has been done here, if you look at the petition, there's a claim for intentional infliction of emotional distress, which is separate from that tort of wrongful discharge. So in those situations, there's also a defamation claim in this case. So those aren't precluded by that exclusivity. It's only the challenge to the termination that would be the exclusive remedy. And as I mentioned, I know that on the Chapter 400 cases, the Von Baal case deals with that.
I think the Court of Appeals decision in Dodovich that we cited deals somewhat with that as well. So there are tort remedies potentially available outside of the actual termination if the termination itself and the manner in which it occurred were to cause intentional infliction of emotional distress type damages. I don't think that would be precluded necessarily by 8015.
This is an interlocutory appeal, do I have that right?
It is, yes.
And if you win on your jurisdiction issue, and we say there's no jurisdiction, he's just got a chance to appeal it after final judgment, doesn't he?
That I believe is correct, Your Honor, and that's something that we've considered. You know, the jurisdictional issue we felt we needed to point out at least. But yeah, I think that
it's possible the case could go away. I mean, it's possible that
well, the
in
dismissal
defending
is still
the
there.
other claims, you could demonstrate that the discharge was not in retaliation, and then the case might go away, right?
Sure, and that's absolutely true. Obviously, some of the other claims are alive at this point in time, and the dismissal obviously is still in place until such time as the case is over. But yeah, that is an issue, and that's one of the things that obviously we considered, pointed out. Obviously, I think both sides didn't devote a significant amount of time to briefing that issue and focused more on the exclusivity and then the public policy and other claims that are involved.
If you don't mind, and I know it's kind of a technical question, but it's a motion to dismiss, and then we have new facts presented. Where does that leave us in terms of a timely, 1904 motion? I'm inclined to think that presenting new case law doesn't motivate me to find 1904 probably, but
the issues were presented were purely legal issues. They were decided as purely legal issues. These new facts weren't new facts at all. If you look at the petition, the fact that he was a sworn officer, the only sworn officer on the scene, if you look at the motions to dismiss, the resistance to the motion to dismiss, the supplemental authority provided by both sides, all of those clearly indicate that he's a sworn officer. The
district court thought it was a rehash, I take it.
Yeah, so there wasn't any new facts that were, the only thing that was presented that was new was some out-of-state authority supporting his position. So it was just additional authority. So there weren't any new facts. There wasn't any authority, new Iowa authority that was asserted. It was some out-of-state authority. So I would agree with the district court that it was a rehash of that. I also am concerned, as is Justice Wiggins, on where that might leave us as we go forward in this case. But that, the facts are what the facts are, and the proceedings are what the proceedings are.
So, Counsel, in Van Bael, we held very clearly that Chapter 400 was the exclusive remedy, and it barred, common law claims for loss of the employment, for the job benefits. Is there anything different about Section 8015?
Actually, Section 8015 would even be a stronger argument for that exclusivity, because Chapter 80 in general sets forth how you hire officers, how you retain officers, how you train officers, how you terminate officers. 8015 more specifically then sets out the specific administrative proceeding. You have you file the matter with the Department of Inspections and Appeals. You then have a hearing in front of an administrative law judge that gets appealed to the Employment Appeal Board, and it says right in 8015, subject to judicial review under Chapter 17A. Clearly the type of statute that this court has long held provides the exclusive remedy for something like this, in this case a termination.
And if the legislature chose to limit the remedy to reinstatement, would we be going contrary to that legislative intent by allowing a separate common law damage with broader remedies?
I would argue that would be the case.
The statute is silent on the question of other remedies, right?
The statute, well, as would be, it's even more silent in Chapter 400. And certainly there's more language along those lines in Chapter 8015. So the legislature, we've been talking public policy. The legislature, and we look to the legislature for public policy. In this case, the public policy that the legislature has evinced is, this is your remedy in these situations. And we're going to give you law enforcement officers, you state law enforcement officers, a lot of protection from politically motivated terminations, because you can't even, we have to keep paying you until the Employment Appeal Board decides that everything was done properly. Even more protections than you would get under the merit system, even more protections than you would get under a collective bargaining agreement, more protections than you would get under a typical contract for employment. Yeah, I think that the public policy of the legislature has been set forth by the legislature for 8015. And if you look at the Hickok case, which is a Court of Appeals decision that we cited in our brief, in that case, the terminated trooper claimed that he was dismissed for political reasons. And that went through a hearing in front of an administrative law judge, a multi-day hearing, went through an appeal to the Employment Appeal Board, went to the district court on judicial review, and ended up in the Court of Appeals. Lengthy, robust, comprehensive administrative process that, as I've mentioned, and I don't want to keep harping on the exclusivity thing, but I think there is an exclusivity issue. You also have the issue, moving aside from that, the fact that in general, this court has held for decades that these wrongful discharge cases are exceptions to the employment at will doctrine.
Oh, but that can't mean that you could, yeah, it's true, the cases involve at will employment, but the mere fact that you have a contract and then are fired in violation of public policy isn't going to eviscerate the public policy tort. I think that depends on what the contract says. You could have a contract that has all kinds of built-in protections, like the collective bargaining agreements that many of the state employees have. You could have a contract for employment that has a termination for convenience clause, which would essentially put them back into an at-will status. So I think it really depends on what the contract says. I don't think that you could assert that any contract employee could bring a wrongful discharge claim under the law that's been established over the last 30 years in Iowa.
Well, and do you agree that Mr. Hedlund could raise his wrongful discharge and public policy claim under Chapter 80 proceedings?
He could certainly say, as he's claiming here, that he was terminated because although you look back and this all comes about because he filed a complaint against himself, but put that aside, if he claims that he was terminated for some improper reason, because he tried to turn someone in for speeding, tried to turn the governor's vehicle in for speeding, was terminated for political reasons, that absolutely can be presented in the 8015 process. And as I pointed out in the Hickok case, that's exactly what was done.
I'm looking at page 91 of the appendix, which is the ruling on the motion for declaratory that I think Officer Hedlund, Mr. Hedlund, put in, and since we deal with the record as it's given to us, this is part of the record. It says, on July 17th, the respondent terminated the appellant from his position within the Department of Public Safety. Then it says, on August 12, 2013, the appellant filed a timely appeal with the Employment Appeal Board pursuant to 8015. So translating that from kind of the bureaucratese, when it says terminated, what you're saying is they initiated the termination process
That's the notice
under
of
the law.
termination, right? There's actually a form that's filed for that.
All right, but he didn't, at that point, he doesn't lose his pay. He continues to be paid. And then he followed through with the process under 8015, at least to a point.
Until he abandoned it, yes.
Okay.
And I think if you look at the actual application for the declaratory order, he indicates in there that he would prefer to pursue his tort remedies as opposed to the remedies under 8015 because of the additional materials. I'm almost out of time. The last point I'll make is Mr. Duff mentioned a couple of cases involving collective bargaining agreements and wrongful discharge cases. If you look at those cases, Sanford, Conaway, those cases, they're purely preemption cases. They don't stand for the proposition that these contract employees can bring wrongful discharge cases, only that the state courts would have jurisdiction as opposed to the state courts being preempted by the Labor Management Relations Act. Thank you.
Thank you as well, Counsel. Mr. Duff, you may present your rebuttal.
I guess first addressing the issue of whether 8015 is his exclusive remedy. A plain reading of the statute would indicate that it's not. I mean, there's nothing in the statute that says this is his only remedy. And if the legislature intended that, they certainly could have said that.
Counsel, does Chapter 400 have that language in it, that it's the exclusive remedy? I'm wondering how you get around the Van Bael case.
I'm not sure if it does or not, Your Honor.
How do you get around Van Bael, or do you have a response to the case generally?
To Von Bael? I'm sorry, I don't.
Can I ask you a question here about your damages here? You know, I guess there's some thought that maybe you could separate the contract from the tort, and it's exclusive remedy to contract, not to tort, and I've heard that bandied around. But if you look at your petition, and only count one's the one that's been dismissed, you still have 2, 3, and 4, you're only asking for, under count one, is paragraph 53, loss of wages, benefits, job security, and other emoluments, whatever that is, of employment. And it seems to me that if 8015 reinstated you, you wouldn't lose that. And then you say, has suffered and will continue to suffer mental anguish, emotional distress, and damages the reputation in regards to the count one claim. But it seems to me if you went through the process and were reinstated, you have no more emotional distress or mental anguish than anybody who has to follow a legal process. And your damages to reputation would be gone because you'd be vindicated. So what damages are left if we buy the argument that you can separate the tort from the contract and pursue the tort remedies and not the contract, because you're not really asking for, it seems, anything more than really contract damages there, but they're a little more because you lost, I guess I found out you lost or abandoned your 8015 hearing.
Well, I mean, he would still have damages for emotional distress, and I think damage to his reputation between the period of his discharge, which was in June or July, up to the time that he was...
Technically wasn't discharged as he's going through this process. It's sort of like an administrative leave thing. He's getting paid, he's getting all his stuff. Now, he's not on the street being a policeman or peace officer, but at the same time, if his rights are vindicated in 8015, I mean, it's a procedure that everybody goes through, and I don't know if the law recognizes, and I don't know the law, maybe you could help me out, mental anguish and emotional distress and damages for going through an administrative process that is set up to vindicate or to ensure your employment rights.
Well, and I maybe to better answer your question, I think he would still be entitled to damages, assuming he could go forward with his public policy claim. He would still have damages for emotional distress that he wouldn't get under the 8015 claim for the period between when he was fired and when he he wins the hearing.
You have to assume that and I am assuming the 8015 is exclusive, and if 8015 is exclusive, those emotional distress damages probably aren't cognizable in tort for the simple reason they go along with the hearing, unless you know of some law otherwise, if it is exclusive.
Right. Well, and I think if that is his exclusive remedy, then all he gets is his job back, and there is no damages for the emotional distress, the damage to his reputation, because I think...
my question is basic. Is he entitled to those damages just by going through an administrative proceeding? That's legally entitled to, even if he had a tort claim, if that is the exclusive remedy. It's a little more basic than what you're saying.
Maybe I'm not... Are you asking whether he would have the right to recover those damages as part of his 8015 claim?
It's a separate tort claim. I mean, they set up this procedure. There are certain things that go along with this procedure. Why would you have a separate tort? You know, the agony of going through the procedure, because if it was reinstated, it'd be over. So you're talking about a short period of time.
Well, I guess the best answer I can give is it doesn't make him whole. It doesn't compensate him for the emotional distress, the damage to his reputation. And when you have, I think, a police officer in particular, if he's discharged because of, there was a press conference with the governor where he said he was a safety issue, a safety hazard, and that is that's a death knell to a police officer, even if it's later determined not to be true. Where there's smoke, there's fire, and you can't undo that. And he is not made whole for those damages under 8015.
But wasn't that after the termination, those press conferences?
It was after the notice of termination is what the state calls it.
Was it after he abandoned the appeal, or before?
It was before.
Counsel, what exactly, and I realize we're out of time here, but we've been tossing this word around termination and discharge. And the notice of termination has been mentioned here. And I'm not sure if that's in the record, but you probably can educate me. Did the notice of termination say you're fired, you're terminated, or did it say we intend to terminate you if the result of the hearing turns out in our favor?
My recollection of the way that the notice was worded was, you're terminated, you have the right to file this 80, I don't even know if it referenced the number of the statute, but it said you have the right to appeal it. So, I mean, for all intents and purposes, his employment was over. Okay. And I'll conclude by saying, which I think I may have said before, sometimes reinstatement is no remedy at all, and it certainly wasn't here, where he would be basically put back into a job with the same people that just fired him. So, for all those reasons, Your Honors, I would ask that you reverse the ruling of the district court. Thank you.
Thank you as well, Mr. Duff. The Hedlund case is now submitted, and we'll hear the arguments in the Richards case.